Hi, I'm Paul McConnell from the McConnell Family Law Group, and I'm going to talk to you for a few minutes about custody, and that is provide all the information we would typically provide in a consultation as it relates to custody questions. Custody, there's really two different types of custody. So there's legal custody and then there's physical custody. With respect to legal custody, we're talking about major decisions. Not the day-to-day routine decisions, but major decisions such as what religion a child or children might be exposed to. Questions with respect to education and any special treatment that might be required with respect to education. Healthcare, God forbid there's any significant healthcare decisions that need to be made. So those are the main sources of questions and decision making that needs to be done with respect to legal custody. Typically, as in 95+% of the time, courts are going to award both parents joint legal custody. Doesn't mean you're going to share the children 50-50. I'm going to talk about that in a minute with respect to physical custody. But with legal custody, 95+% of the time, courts will award joint legal custody. In fact, the statutes even say that that is the presumption. The rare times when it's not is when there's really profound mental health issues, somebody's incarcerated, profound substance abuse issues that have been documented and have caused problems in their lives as it relates to raising the children and the like. But usually it's going to be joint legal custody. Now, sometimes when it comes to making final decisions in these non-routine areas, occasionally courts will award one parent or the other final decision making with respect to a particular area after they've shared information and invited the other parent's opinion on matters. So for example, parents where it's a kind of a high conflict area, they don't get along, communication's not good, and there's joint legal custody, but a court or a judge may say, okay, but with respect to health care, in the event the parents can't agree, the mom or the dad, as the case may be, will have final decision-making authority on that particular issue. For the routine issues that come up on a day-to-day basis, whatever parent is taking care of the children at that time makes those decisions. Physical custody, okay, that is different, and that's what people often think about in terms of how much time I'm going to have with the child or children. And that can come out in a number of different ways. It can be a purely shared physical custody arrangement where each parent has the child or children 50% of the time, or near 50% of the time. It's typically not 1 week with one parent and 1 week with another parent. More commonly, there's for 50-50 sharing plans, it'll be something, for example, every Monday and Tuesday is mom, every Wednesday and Thursday is dad, and then you alternate the weekends, Friday, Saturday, Sunday. But that's like a 2-2-5, so there will be 5 days in a row. Alternatively, it could be Monday, Tuesday, mom, Wednesday, Thursday, dad, and then mom's weekend, Friday, Saturday, Sunday, but then the next week, Monday, Tuesday, dad, and then Wednesday, Thursday, mom, and then dad, Friday, Saturday, Sunday, and so forth. And then the holidays we typically find ways to agree to how to split them up and share them equally, with some give and take, obviously. Other times, 50-50 or shared parenting doesn't make sense. Sometimes a parent has just been the primary caregiver for many, many years, and it just makes sense to keep that routine in place. Other times, one parent may travel a lot for work and not be available and the like. So it's not, by no stretch is 50-50 the most common. I was just giving you some examples of how it plays out when it is shared. It is more common nowadays, and when a father, typically, not to be sexist, but when a father wants to have a 50-50 custody, and he's able to do so, the default going in is going to be that he's going to get it. So that's kind of the starting point, if you will. And then if the other spouse didn't want that, they'd have to articulate and persuade a judge differently. Now, I talk in terms of judges. Doesn't mean that every case is going to go to trial. In fact, few do. But these judicial norms inform practitioners and that we share with clients in terms of different areas in which to compromise and find agreement and the like. So at the end of the day, though, with respect to physical custody, it shouldn't be a tug of war as to what matters most to mom or dad. It's what's in the best interest of the kids. What is sincerely in their best interest. And quality matters more than quantity. So just keep that in mind. Some additional miscellaneous questions and topics we sometimes get. Occasionally we'll get questions such as, can I force the other parent to spend time with the child or children? Or what if the other parent's not reliable? Well, you can't really force a parent, regrettably, but we appreciate the spirit and wanting to do so. That's a good point of view and mindset for your children, to have a relationship and to encourage a relationship with the other parent. That's a positive thing, but it can't be forced. Sometimes some parents are a little bit unpredictable, if you will, and they'll fulfill some of their responsibilities on their parenting time, agreed upon parent time, but then at other times they're habitually late, or they don't show up, or they just pass on a weekend, for example. And there are some remedies for that. There can conceivably be a contempt motion for failure to file an order. More likely, though, if a parent is habitually doing that, would be to file a motion to modify child custody, which I'll talk a little bit more about here in a second, but to modify it, to change it such to reflect whatever that parent really can do or has consistently done. So that's a potential remedy there. Another question, does it matter if you're married? No, doesn't matter. If you've never been married and you have children together, there's still custody issues to be resolved. Sometimes people want to know in a parenting plan if a parent needs to have primary residence, or they want to argue, even on a 50-50 sharing plan, which one has primary residence. I will say that historically it used to matter with respect to enrolling somebody in a school district. However, that's rarely the case anymore. And so in true 50-50 sharing plans, more often than not, we don't even reference who has primary physical custody. But it is sometimes done, but it's pretty insignificant from a legal perspective. Other issues that come up, modification. Just because you have an agreement doesn't mean it can't change ever. In fact, we would recommend that parenting plans be revisited about approximately every 3 years, because children that are 5 years old are far different than they are at 10 and 15 and the like. So it makes sense to revisit them and update them. Doesn't necessarily mean that you have to involve a lawyer, or lawyers, but you should reduce it to writing. And if you want it to be enforceable, it would need to be ratified by the court. You can just memorialize an agreement and submit it to a court to ratify, to update it, if you will. So we recommend updating custody plans every 3 years or so. Another thing with respect to modification is sometimes both parents don't want to, but one parent does, right? So then you would file a motion to modify an existing custody agreement or custody order, and then the burden is on the moving party, whoever wants to modify it, to establish that there's been a substantial change in circumstances that warrants changing the custody plan, and the court's going to look at it in terms of through the prism of what's in the best interest of the children. Relocation's another issue. It's beyond the scope of this particular video. We'll have a separate video on relocation explicitly. Suffice it to say, for this video, if somebody wants to move out of state in particular, or a substantial distance away, that obviously can interfere if they plan on taking the kids with them, or they would like to take the children with them. That can obviously interfere with the other parent's ability to parent the children if he or she's not also willing to relocate. And so when there's disagreement that needs to be litigated on relocation, then the moving party has the burden, and it's often difficult, but definitely not insurmountable. Just depends on the specific facts and circumstances. Okay, what matters a lot, or one question we get a lot, is with respect to cost. Suffice to say that when we litigate in court and have to go to a trial, with respect to custody, it is by far the most expensive practice that we have within the various practice areas that we have, compared to divorce and prenuptials and the like. Litigating custody, whether it's in concert with a divorce or on its own, whenever parents are fighting over custody and they need to go to court and get a judge to decide, it is profoundly expensive. Not $5,000, not $10,000, tens of thousands of dollars typically, which is also often an encouragement to find solutions outside of going to court and having a trial. And there are various ways to accomplish that. We can mediate cases. You can hire us to be a mediator, and we can meet with both parents and try to find a resolution to what's in the best interest of the children. We can also refer people to see co-parenting counselors. We do that a lot in our practice here. We have a number of contacts, and where you don't even necessarily need an attorney. We meet with you to get some context, and we'll send you to a co-parenting counselor where you go together, and together you work through and hear the other person's perspectives and make compromises and work with a neutral co-parenting counselor who then gives us the agreed upon terms, and we memorialize that into an agreement and a stipulated agreement. We provide it to the court, and then thereafter becomes a court order and your custody and parenting plan. So there are some other alternatives to avoiding court. For those that can't reach agreements, either through negotiation or through mediation with an attorney or through working with a co-parenting counselor, and you do have to litigate, but you can't afford tens of thousands of dollars to litigate it, we understand. We've created a consulting practice or coaching practice where we can help you to represent yourself. We wouldn't go to court with you, but we can give you strategy. We can talk to you about what witnesses you might want, what witnesses don't make sense. We can ghostwrite particular documents for you and help you represent yourself the best way practical without having to spend tens of thousands of dollars. We hope this helps. We have separate videos with respect to child support, which I'll talk actually about a moment here in a second, and child support for high net worth clients, and a separate video on relocation and the like. And of course, make a consultation with us, and we can talk to you about the consulting and coaching practice if it looks like you need to litigate and go to trial, or just talk to us about the different avenues, and we can conceivably try one, and then if that doesn't work, try another. With respect to child support, I'll just touch on it briefly. Child support is implemented by a statute here in Connecticut. It implements something called the Child Support Guidelines. And everybody in Connecticut, the practitioners of courts, rely on a software program, most typically family law software, which we input incomes, the number of children, and out comes a presumptive number that's relied upon by the courts. It's, for the most part, pretty darn objective. You put in the mom's income, put in the dad's income, the number of children, and it calculates this is about how much, given these incomes and these number of children, in Connecticut on average they would spend, for example, $500 a week for 2 children, and it allocates what the share would be per parent, and then at the end of it is a presumptive amount that the higher income earner would pay the lower income earner. It does matter who has primary residence to a degree, but typically the higher income earner is going to pay the low income earner. There's deviation criteria. So if somebody has to travel a great distance, for example, is one deviation criteria. A shared parenting plan is a deviation criteria for parents that have somewhat similar incomes. How to define that? Not defined. It's a gray area, but in all events, you can deviate for a shared parenting plan, but it doesn't go to zero just because it's 50-50, and we could talk about more why in more detail if you would like to meet with us for a full consultation. We're still providing consultations at a discounted rate, not our full hourly rate, but for up to 1 hour, we'll provide a discounted rate to talk about the particulars of your case. Thank you.